Okay, so now that we've talked a bit about liability to the client, let's talk about liability to non-clients or third parties. Typically what we're talking about here is liability for parties who are not mentioned or referenced in the contract between the accountant and the client. All right. And so just as background or something to think about, when we're talking about accountant's liability, usually it's a situation or circumstance where the fecal matter has hit the fan, so to speak, and oftentimes the business is judgment proof. And oftentimes many of the individuals may not be deep pockets, or they may not have deep pockets sufficient to satisfy the any adverse judgment. All right, so who's left around? It's the accountants. All right, and that's one of the reasons that auditing services come at a premium, is because there is a fair measure of risk, and even with appropriate due diligence, you can filter some of the risk out. There's always going to be some risk that you get sued, even if you've done everything appropriate as an auditor or as an accountant. So let's talk about the 3 rules governing accountants' liability to third parties. And let's start with the fringe rules and then kind of get to the rule that's in application in most states. So let's start with reasonably foreseeable users rule. All right. This is a very broad rule, and by its definition, pretty much any reasonable user, if we're thinking in audit context, any reasonable user could sue the accounting firm for their audit report per se. And so that would be, if you're dealing with a publicly traded company, that's any investor that's lost money as a result of reliance on misleading financial statements, is any lender who has made a loan after reviewing misleading or wrong audited financial statements. Pretty much anybody who could have reasonably relied on the financial statements, and that could have reasonably been foreseen, the accountant's liable. So that's a very broad rule. It's very harsh against the accountants. It is an extreme minority rule used in a handful of states. Right? Accounting services in these states do cost considerably more. Let's talk about the ultra mares rule. All right. So there's a good chance, I know if you had me for 2080, you're familiar with Benjamin Cardozo and several of his opinions in the New York Supreme Court, including Paul's Graph versus Long Island Railroad, which was the proximate causation test. Also the Jacobson-Young versus Kent, which was the constructive substantial performance, the doctrine of substantial performance, where the house was built with the wrong brand of pipe. Well, the ultra mares rule also comes from that same court and that same author, Benjamin Cardozo, who, if you study law, it's impossible to avoid a Cardozo opinion, right? Because in legal environment, this will be your 4th case from that court. But ultra mares, another very pro-business, very anti-citizenry, anti-third-party decision, like many that we found from the New York state courts in the 20s and 30s. All right. So the ultra mares rule states that you pretty much need to be in the contract, or it says privity of contract or near privity to sue, which really means that you are either the client that the accountant contracted with, or the client contracted with the accountant for your behalf. I'll give an example. So if I'm getting a set of audited financial statements for the express purpose of gaining a line of credit from a bank, and the auditor knows this, that is near privity. So the bank would be near privity in that case. But those would be the only parties that can sue under the ultra maris rule if the accountants screw the pooch and get it wrong. Alright? So that's an example of the ultra maris rule. Also a minority rule. Alright? Observed in in more states than reasonably foreseeable users. But the rule that's effectively present in most states is what we call a restatement rule. So you guys may recall a restatement is when we attempt to codify or write down common law. All right, that's what a restatement is. So the restatements themselves have no legal effect, but what they do is they restate, or they state, common law in a vast majority of jurisdictions. So reading the restatement will tell you what you can expect from a legal standpoint due to existing common law. Well, under the restatement rule, accountants are liable to foreseen users of financial statements, and this is the majority rule. So this is kind of your middle of the road rule between the harsh, at least for third parties, ultra maris rule, and the harsh for the accounting firms, reasonably foreseeable users rule. And it gives the accounting firm, kind of focuses who they're going to be liable to. They have to either be known or foreseen, right, to hold the accounting firm liable. It is worth noting that is the restatement rule is used in both Ohio and Kentucky. Okay. Attorneys' liability to third parties. Generally, there is none, quite honestly, unless there's some shenanigans, if you will, or some misbehavior from the attorney, right? If the attorney has committed fraud or malicious conduct, then there may be a case to hold the attorney liable for to a third party. But for non-clients, you really have to have fraud or malicious conduct to hold the attorney liable. Okay,